our main objective in organizing this is very clear. The judgments of the Supreme Court, as we have seen, are sometimes right and sometimes wrong, and sometimes corrected by themselves, as we have seen in many cases, including the ADM Jabalpur case. But our understanding of the law, the people's understanding of the law, and the understanding of the law of legal scholars must be objective, must be truthful, must be valid, and we must evaluate the judgments of the Supreme Court against our own understanding of the law. So we must understand what is the correct law on social justice, on reservations, of the Constitution, as intended by the father of the Constitution, Baba Saheb Dr. B.R. Ambedkar, and his colleagues from the social justice movement who fought against grave odds and created a unique constitution, unparalleled in the world, with a very rich set of provisions of social justice inside that constitution. We must have a correct understanding of the Constitution so that we can judge the Supreme Court's work, which may go this way and that way, against a correct understanding of the Constitution. And our argument to you today is that some of the Supreme Court's decisions narrowing down scheduled caste, scheduled tribes' right to reservation promotions are, in my view and in view of some of the others, wrong. And we hope that, like ADM Jabalpur, in the course of time, it will get corrected. But we must know why it is wrong, what is wrong with it, so that we have the correct understanding. We, the people, the Constitution belongs to us. We must have a correct understanding of the Constitution as far as we are concerned, based on law, based on correct principles of legal interpretation. So that's what we will offer to you. Before I request Madam Indira Jaising to start the proceedings, I would like to take 2 minutes to give you two snapshots, one from history and one from a recent judgment of the Supreme Court. The history that brings us all together here clearly is the history of the development of our social justice provisions in the Constitution. While the Constitution was being enacted, two scheduled caste members of the very distinguished scheduled caste members of the Constituent Assembly, Sri V.I. Muniswamy Pillai and Sri S. Nagappa, spoke to the Constituent Assembly on the 27th and 28th of August 1947, the 12th day of our independence. Mr. Muniswamy Pillai said, "Sir," I'm quoting now, "Sir, there is a fear in the minds of some of my friends, especially the scheduled castes, that the Hindus are coming into power." He means upper caste Hindus. "And that Hindu Raj is coming into force. And they may introduce the Varnashrama that was obtaining years back again to harass the Harijans." This is what Mr. V.I. Muniswamy Pillai said 12 days after independence. We were very happy that the British had left. We were, due to the struggle of the Dalits and the common people of this country, we were very happy that India had won its independence. But on the 12th day of independence, Mr. Muniswamy Pillai informed the Constituent Assembly in a speech that there is fear in the minds of some of my friends, the scheduled castes, that the Savarnas are getting into power and Hindu Raj is coming and they may introduce the Varnashrama and take us back, years back, to Varnashrama to harass the Harijans. Mr. Nagappa, his colleague, also scheduled caste member of the Constituent Assembly, a very distinguished member also with many rich contributions to the Constitution. Mr. Nagappa said, it's a slightly, few lines more intervention. He says, "I would suggest that it would have been better if it has been provided in the Constitution that a particular community will have its share according to its population." So Mr. Nagappa said, "I want every community to have its share according to its population." And he says, quote, "I do not want to rob Peter to pay Paul. It is very bad policy. I want my due share." Then Mr. Nagappa says, "Although I am innocent I'm ignorant, I'm dumb, yet I want you to recognize my claim. Do not take advantage of my being dumb. Do not take advantage of my being innocent. I only want my due share, and I do not want anything more. I do not want, like others, weightage or a separate state. No one has a better claim than us for a separate state. We are the aboriginals of this country. So Mr. Nagappa told the Constituent Assembly, give us our due share or give us a separate state. But we don't want to be taken back to Varnashrama Dharma, and we don't want to be taken back to the order where we were treated as less than human beings. This was the demand that was placed, that we want our due share because it is our claim, not because it will lift us out of poverty, not because it will advance us to the so-called state of the upper classes and upper castes. God forbid if we were to be like that. That was not the basis. It was not for development, not for representation, not for any of these purposes that are being used in order to justify reservations. Mr. Nagappa said, I want my due share because it is my claim. Because I'm an Indian, I want my claim. That's what he said. Now, in contrast, I will just end by quoting to you a sentence from a 2018 September judgment of the Supreme Court on this issue of SC/ST reservation and promotion. And that is Jarnail Singh and others versus Lakshmi Narayan Gupta, 26th of September 2018 judgment. And the Supreme Court says, according to us, the Nagaraj judgment has wisely left the test for determining adequacy of representation in promotional posts for scheduled caste, scheduled tribes to the states, for the simple reason that as the posts get higher, now this is the important point that the Supreme Court is saying a few months ago, as for the simple reason that as the posts get higher, it may be necessary, even if a proportionality test to the population as a whole is taken into account, to reduce the number of scheduled castes and scheduled tribes in promotion posts as one goes upward. A shocking statement from the Supreme Court. It says, according to us, it may be necessary to reduce the number of scheduled castes and scheduled tribes in promotional posts as one goes upwards. This is for the simple reason that efficiency of administration has to be looked at every time promotions are made. As if the increased number of scheduled castes and scheduled tribes will reduce efficiency. This is what the Supreme Court is assuming. As has been pointed out in Indra Sawhney, there may be certain posts right at the top where reservation is impermissible altogether. Why? What is the basis of that, other than pure casteism? For this reason, we make it clear that Article 16(4)(a) has been couched in language which would leave it to the states to determine adequate representation depending upon the promotional post that is in question. So the main source of resistance is they do not want scheduled castes and scheduled tribes in the highest positions of the country. And that is the purpose of the resistance, but that is also the purpose of creating this republic, that the common people, the poor people of this country will occupy the highest positions of this country. So please see the contrast between the fear of Muniswamy, Mr. Muniswamy and Mr. Nagappa in 1947 and the view expressed in 2018, 71 years later, by the Supreme Court, which has not learned the lesson, has not yet heard the voice of Muniswamy and Nagappa. And please tell me, is there any other instrument except reservation that will force this insensitive, deaf, and blind elite to recognize and hear the claim of Muniswamy and Nagappa? With this, let me turn to our first speaker, Madam Indra Jaisingh, and request her to kindly address us. We are looking forward very much to hearing you. Madam Indra Jaising.